Hiya, guys. Trust you all well. Just a real quick one. It's Richard Anter here from Wealth Guardian Education. Just wanted to answer a question from a Wealth Guardian member and also part of the Facebook group, asking the question, why is the legal title put in trust on Land Registry? Okay, so I'm not really very, very long, a bit of an impromptu live. So I'm sure you can catch up with me on the replay if you've missed the live itself. So, and apologies for any background noise, slightly noisy environment in the office today. And I've not gone into a quiet space as such, but hopefully you can hear me okay. All right, so let's get to it. So let's just share my screen real quick. And the question is actually a very good question. It's a valid question. Sorry, 2 seconds. Let's share my screen so you can see what I'm seeing. Okay, so if you're on YouTube or Facebook, it's really quick if you can just let me know if you can hear me okay. I'd really appreciate that. Hopefully you can. Hi, Steve. Good to have you on board. And obviously, I'm sure, again, loads of people will join the replay. Let me know if you can hear me okay. You should be able to. I'm hoping. Right, let me just crack into it anyway, real quick. So, right, so why is a legal title put in trust on Land Registry? Again, apologies for any background noise you might be hearing. Okay, can everyone just hear me okay? I'm just double check to put a Y in the chat box. You can actually hear me okay? Let me know real quick. Perfect, thanks, Steve, appreciate that. Right, okay, so why is legal title put on trust on Land Registry? So I just need to backtrack a little bit to explain what is going on and so people can understand. So, because not everyone might be up to speed with how the whole thing works. So, first of all, you have your house, okay, property that you own. All right, so I'm going to put your home, okay. Now, first, most people have a mortgage, all right? So I'm going to just put this circle around here, and let's say that equals your mortgage. Okay, let's start that part again. Let's keep it really simple. Let's say £100,000 mortgage, okay? And this is your house, all right? Now, with that in place, you will, on the Land Registry, it will say initially who the proprietor is, which will be you, first of all. Then it will have normally on the part one of the Land Registry title, the mortgage lender. All right. Some lenders put a charge, others may put a restriction. But normally it's you first, then afterwards it's the mortgage lender, because basically you own the house outright initially. Then when you went to get a mortgage, you exchanged your house, the land, shall we say, the title, in exchange for some money. In this case, £100,000 in this argument, in this example. All right. So on the Land Registry, who's named on it? First and foremost, it's you, then the lender. All right, and then you got a title number. Let's say ABC 1, 2, 3, 4, 5. All right, on Land Registry. So that's how it normally would work. And typically, what happens is, again, I just redraw it out. You got your house. Okay, you got your house. Again, remember the mortgage amount is £100,000. All right, and now you got equity in the property after like 10 years, whatever. House value is increased. All right, and so the value, let's say, is £500,000, right? £500,000. So anyone want to tell me what the equity in the house would be if the value of the house is 500,000 and the mortgage is £100,000? What's the equity going to be in the property? You can tell me that real quick. There's probably a slight delay on the live. I do appreciate that. But anyone want to hazard a guess? All right, just for sake of time, I'm going to put it. So the difference between there and there, so it's £400,000. All right, that's the what most people call the equity or the redemptive equity in the property. All right. So what happens is the mortgage company has a liability, or sorry, has a interest of £100,000, and that's going to be shown on land registry. So lender, amount borrowed £100,000, and then everything else, which is what we call the beneficial element, right? The beneficial interest, okay, the equity, the beneficial interest is whatever the market deems it to be. So if the market says it's £500,000 and the lender has a obligation or a charge of £100,000, which is the form of a mortgage, then the difference is £400,000. So when you go on the land registry, that's what you'll see. And the legal title owner is the proprietor. Okay, so the legal title owner is the proprietor. Okay, which is you. However, if you've got a mortgage, then or what we call a cloud of title, someone else has an interest in the property, okay, then the mortgage lender will also appear on the land registry. But the proprietor is you, and that's the legal owner. Okay, the mortgage lender has a legal interest. Okay, so now the question that was asked by Rich was, why is a legal title put in trust on land registry? So effectively, when you want to put your property into a trust, whether it's private trust or public trust, as we talked about yesterday. So let's go back to. All right. So now, when you put your property into a trust, if there's a the option number one, or situation scenario number one, is if there's a mortgage in place already. Okay, whether it's private trust or public statutory trust, all that will happen is you have your house. If it's a mortgage on the house, so mortgage, let's use the example of £100,000, and then we go back to the example of if the market value is equal to 500,000, okay, the equity is equal to 400,000. Keeping it really simple, if you put the house, well, they say the house, or the put quote unquote, it's not the house, it's the title, into trust for the value of the house value, which is 500,000. I'm not going to go into any taxation or anything like that. That's another subject altogether. But just for argument's sake, you put £500,000 worth of a house into trust. Okay, right, into trust. Then what will show is that you have if there's a mortgage on the property, the only way to identify that there's some kind of trust or third party relationship going on is that there'll be a restriction showing. All right, restriction. Typically, yes, you place a restriction if there's a mortgage in place already. Now, so does everyone understand that? Yeah, I'm hoping everyone understands that. Now, if there is no mortgage, this is where we're going to answer the question: well, why does the legal title appear on land registry? If there's no mortgage, then what does that look like? You have your house, it's mortgage free, it's worth £500,000. So the equitable value is £500,000. Who's the proprietor? Well, the one who bought the house. Okay. And in English law, UK law, there's no separation of what there is, but you can't legally do so anymore. So under the Law Property Act, the legal owner until you say so, is the beneficial owner. All right. So if you do nothing about it, then pretty much the legal owner owns the whole of this estate, currently £500,000. So if it's not in trust, then that whole everything is exposed. There's no protection at all whatsoever. All right. And under the UK law, they just recognised the legal owner only. There's no separation between the legal owner and beneficial owner. They just recognise the legal owner until you say something else. Okay. So if you put it into trust, well, but first of all, before you put it into trust on land registry, the proprietor's name is the one that appears. All right. Only. And at law, you are by default deemed to be the legal owner. In other words, a trustee of your estate. Okay. So anything goes wrong, you're the one in trouble. Anything, anything owed, any debts, any court cases, any proof of ownership, you're deemed as both the legal owner and the beneficial owner. In other words, probably the better way to say is you have full title. Okay. It's not a Lloydal title, it's full title. All right. It's not a Lloydal, it's just full title. Okay. All land is in trust to the Queen, so you can't have a Lloydal title. You just have full title as far as the title to land is concerned. All right. As far as the title to land is concerned, because that's what you own, the title, not the land itself. You own the title, a parcel of land. Okay. You own the title. That's what you own. Okay, just so for clarity's sake, you own the title, not the land itself. All right, and so you're the full title holder, also known as the legal owner. So if you now say, right, I want to put this into trust, because you are the settlor, full title owner. Hopefully, I've not confused anyone. Then the settlor is the only one that can put something into trust. You own the land or the title to land, and so you place that title to land into trust. Okay, you declare a trust, and only the settlor can do that. Or another way around, how I normally do it, is you have the settlor, you have the beneficiary, you have the trustee. The settlor is the one that places the property, okay, into trust. Okay, effectively nominates who the trustee is and nominates who the beneficiaries will be or who they are. All right. So because the settlor must have full rights, title, and interest to any property that they deposit into trust. If they don't have these facets, he can't put it into trust. Because the settlor has that, he can put that into trust. Okay. And what I said before is that you are the full owner of the property. You have full title, so therefore you can deposit that into trust. If there's no mortgage, then there's no cloud of title on the land. So the whole of the land, or whole of the land title, should I say, not just the equitable part, but the whole of the land title is going into trust, not just the equitable portion. So to answer the question, yeah, that's why the whole the trust name is now named on the land registry in full, because the whole of the asset, not part of the asset, the whole of the asset is gone into trust. So as far as land registry is concerned, it belongs to the trust, and so it'll be the name of the trust that appears on the land registry for public trusts. Okay. If you could, I don't get involved with anything like this as far as wealth guardian is concerned for any private trust aspects. All right, just purely for an asset protection purpose. So anyone who's doing this by themselves without any legal advice, just be very, very careful what you're doing. I'm not going to get involved in that, but in terms of answering a specific question, why is it the trust? Sorry, the why does the specific question, why is a legal title appearing on the land registry? Okay, or why is a trustee appearing on? Why is a trust details appearing on land registry? Because it's the trust that owns the asset now. The settlor's given it to the trustee in trust. Okay, you've given it a trust name, ABC Trust, Family Trust, whatever it's called. All right, so that's the one that appears on that registry because the trust owns the asset. As long as there's no encumbrance on the asset, like a mortgage or anything else, or no other cloud of title, then the trust owns it in full. Otherwise, if there is a mortgage or something like that, then all you can put is the equitable portion, not the full legal title. So does everyone understand that? I don't know. I hope I've explained that okay. Any questions? Just type away if there are. All right, or just put it in the post and I'll try and come back to you either on YouTube or Facebook. I'll come back to you in the comments. Okay, so that's to answer the question. So just to recap really briefly. All right, whoever you're going to set the trust up, whatever property, don't care if it's a house, a Kit Kat that you own, whatever. Okay, whatever the property is, the settlor is the one that deposits that property into trust. How is it done? The settlor must convey title to the trustee, else there is no trust, and the settlor must establish who the beneficiary is, what we call the object of the trust. Okay, something called the three certainties. All right, to prove a trust exists. So once that's done, assuming there's no cloud of title, in this case for a house, there's no mortgage or any other third party interest, then basically the name of the trust appears on land registry. In the UK or Ireland, Scotland, wherever in the world that utilises trust, it appears on the registry of some form to identify that it's a trust that owns the land now, not the settlor anymore. All right. Obviously, the whole conveyance of property to trust splits the title into legal ownership and beneficial ownership. But as far as the public needs to be aware, because the public does not recognise a beneficiary, okay, only recognise the legal ownership. So the trust name is what appears on the land registry. All right, that's just how it works. So I'm sorry if the video kept on cutting out. I'm not sure why that's happening. It's an extremely fast internet connection at my end. So hopefully you can catch the replay. Any questions, just post it in the comments below and I'll definitely come back to you. All right. Thanks for your time, guys. I know it's a very quick one, but I just wanted to answer the question. Okay. Speak to you all real soon. Thanks for your time. Thanks for your comment. Thanks for your support. Cheers.